Here we go again with the next part of our what in the hell took so long to fire this judge. We have count three of five. We might be able to get through 3, 4, and 5 in this video. Depends on how long it takes. So let's just get into it. Okay. Improper use of capious warrants and bonds to compel payment of fines and costs. What does that mean? Well, under local rule 4.07 of the Cleveland Municipal Court, at the time of sentencing, a defendant may request time to pay their fines and costs. The sentencing judge may grant that request and set a payment due date. The defendant is then directed to the clerk's office to complete a time to pay contract. If the defendant cannot pay the fine by the due date, the defendant can file a motion to set an ability to pay hearing, which the clerk's office sets before the sentencing judge. So what that is say you have to pay your fine by October 20th. You can't. You can file a motion to request a hearing to extend your time. And that goes before the judge, the sentencing judge. So if it was former Judge Carr, you would go back in front of Judge Carr. Well, in her answer to Relator's amended complaint, she stated that she was unaware of the dictates of Local Rule 4.07 of the Cleveland Municipal Court. This makes me so angry. You or I are ignorant of the law, we go to jail. There's a good chance we get in some kind of a trouble. It might be civilly, it might be criminally, but there's a good chance that we're going to get locked up and at least spend some time in jail, fines, fees, and whatnot. But this Thundercat is able to not effectively perform her duties, but she's able to sit on a bench and not know the freaking local rules. Like, she sat on this bench for 10 years. At this point, we're at like 8 years in, because this is all around 2020, 21. And she took seat in January of 2012. Okay, so how many years, how many people did she screw over this way? I'm working on finding that out. I am so angry. All right, but in her testimony during the disciplinary hearing, she stated that in 2017, her bailiff told her that the clerk's office had a very low success rate when it came to actually collecting fines levied by the court. Carr interpreted the bailiff's statements as a suggestion that she ignore Local Rule 4.07, and she followed that suggestion. She took it as a suggestion that she don't have to follow any kind of rules, and she can do things her way. So this lawyer turned judge, lawyer that was an assistant prosecuting attorney for Cuyahoga County, which is this court, is taking the word of a bailiff and a recommendation of a bailiff. No offense to the bailiffs out there, but you're not a licensed attorney, 13 years as a prosecutor, and at this point 8 years as a judge. You're going to take the bailiff's word on something and a suggestion? As a result, when a defendant was convicted of an offense, Carr would set a date for the defendant to pay his or her fines and costs. Immediately after imposing the defendant's sentence, and without any motion by the defendant, she would set her own ability to pay hearing to occur a few days after the TTP. That was the time to pay due date, without notifying the defendant or the clerk's office. How the hell are you to know that you have to show up in court if you're not told and the clerk's office doesn't send you your subpoena or give you notice? When the defendants failed to appear for those hearings, Carr would issue bench warrants and set a bond between $2,500 and $25,000 based on the defendant's failure to pay fines and costs that were typically just hundreds of dollars. She would then write on the journal entry, post bond or pay the fines and costs in full. No community work, service, or time to pay. She would also stamp on the journal entry, defendant does not qualify for the in-neighborhood or over-the-counter Judge Pinkey S. Carr. What does that mean? That means that she took these people that had to pay court fines and costs and set a date to have her own time to pay kind of hearing without letting them know or the clerk's office know. She would then assign a search, or not a search, but an arrest warrant, a bench warrant to them, a capias warrant that is there to be picked up, and the fines ranging from the bond conditions from $2,500 to $25,000, which is way over the amount of the actual fines and costs. So that if they paid the fines and costs, she'd get out. They could get out, and they wouldn't have to pay the bond amount. So they paid the lower amount. She created debtors' prisons, which are illegal. A debtor's prison is illegal. This is just, so ridiculous. So by tying the bond to the amount of the fine and cost, she was compelling the payment of fines and costs through incarceration, which is contrary to the law. Ohio Revised Code 2947.14, which requires a judge to conduct a full hearing regarding their ability to pay a fine, which they have a right to be represented by counsel, testify, present evidence, and permitting the judge to commit an offender to jail or workhouse upon finding the offenders if they're able to pay or not. So say you had $2,000 in fines. We'll just call it $100 a day. So you could do a workhouse and you do 20 days. It's $2,000. Basically, it's work release, right? The board noted this court has issued Carr a bench card outlining court practices for collecting costs and fines in adult courts. The card is replete with citations to case law and statutes indicating that a person's ability to pay must be considered when assessing and collecting fines. Like, seriously. The bench card states that a formal hearing under Ohio Revised Code is the sole and exclusive method for imposing a jail sentence for willful refusal to pay a fine. Keyword, willful refusal. Blatantly not pay it. They're not given a chance to pay because she sets a hearing a few days later, then issues warrants. And this is absolutely absurd. All right. So she admitted that her conduct resulted in the arrest of 6 defendants, 5 of whom were incarcerated for some period of time as a result, which I'm trying to find out who those 6 people were. I'm working on it. She admitted at the disciplinary hearing that her use of capias warrants, and you can't read that, no. Her use of capias warrants and incarceration as a means to compel the payment of fines and costs by tying the bond to the amount of the fine and cost essentially created a modern-day, debtor's prison. The board found that Carr eventually discontinued this approach to enforcing the payment of fines and costs that she gave, and that she gave a characteristically colorful explanation for doing so. In open court, former Judge Pinkey S. Carr states, and I quote, "You notice I'm no longer the bill collector for the clerk's office. I'm not your bitch. You get it? Collect your own money. There you go, player. Collect your own money, player. I'm not your bitch. Run, tell that. How you like them apples, suckers?" This is a sitting judge in open court saying this crap. Like, I am dumbfounded that all this crap went on and continued to go on for years. She stipulated, and the board found that her conduct with respect to count 3 violated Judicial Rule 1.2 and 2.2 and Professional Conduct Rule 8.4D, and we adopt these findings of misconduct. Now, count 4. We're on a roll. Count 4. Lack of decorum and dignity consistent with judicial office. I doubt we're going to get to count 5 because that's going to be a video in itself because it's insane. All right. In addition to violating statutes, rules, and court orders designed to protect the legal interests of the public and the litigants in courtrooms throughout the state, Carr presided over her courtroom from a bench covered with an array of dolls, cups, novelty items, and junk that her own counsel found to resemble a flea market. You know what? We're just going to put a picture of her bench right here. And we're going to pause it for a few seconds. And we're going to just digest the garbage on this. This looks like a flea market. This looks like, a knick-knack. It's one thing if this is in her office in the back. But to have the bench littered with this crap is so unprofessional and asinine that she was allowed to behave this way. And this, again, I'm going to say it again. When power goes unchecked, this is the kind of person or representation you get. She testified that her bench had been that way since 2012. Now, we're talking like 2020-ish now, 2021. But that she had cleared it off a few months before her disciplinary hearing. She also violated rules governing appropriate courtroom dress, order, and decorum. From the appearance of her bench to the way she dressed and the way she treated the attorneys, litigants, and staff in her courtroom, she undermined public confidence in the independence, integrity, and impartiality of the judiciary. Now, the Cleveland Municipal Court addresses proper attire. All right. It states that all persons entering the court shall conduct themselves with deference for the court, displaying respect for the law, the judge or magistrate, parties, counsel, deputies, bailiffs, and staff. It further identifies shorts and tank tops as potentially inappropriate dress. But despite the dress and decorum expectations for the general public, Judge Pinkey Carr presided over her courtroom wearing workout attire, including tank tops, t-shirts, some with images or slogans, above-the-knee spandex shorts, and sneakers. You read that right. Sneakers, spandex shorts, tank tops. And that's the sitting judge. We're not talking a black robe over top of that, because if that's the case, it doesn't matter. We're talking like that's how she would sit on the bench. Like someone snuck through there and got past the bailiffs and just sitting on the bench going, playing judge, bang, 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 order the court, Nope. Carr was aware the public took notice of her unconventional appearance. She once told a defendant's counsel, "Your client was scared to come in." Officer Gray said he asked her, "Well, where's the judge?" She was like, "She's in there." And he was like, "The one in the t-shirt?" He said, "I'm calling my lawyer." He said, "This couldn't be real." She then explained to counsel, "I dressed up Monday, Tuesday, and Wednesday. It's not happening today, and tomorrow is a national holiday, Juneteenth. I'm not doing it today." It's like it was casual Friday. Like, there is no such thing as casual Friday in a court as a court professional. The board found that Carr revealed in her lack of decorum, telling one defendant who apologized for his own attire, "You see how I'm dressed? I have on my Cavs t-shirt." After another defendant expressed surprise that he had been found not guilty, Carr responded, "You can trust me. I'm not dressed like a judge, but I'm really the judge." During a series of proceedings in open court, Carr maintained, this is a dialogue with her staff and defendants about the television series P-Valley. I have no freaking clue what the show is. I don't care. All I know is it's about a Mississippi strip club, and she routinely referred to one of her bailiffs as Ms. Puddin or some variation thereof. She asked one defendant if he knew Ms. Puddin from P-Valley, and she teased another bailiff about driving to P-Valley to find him a little girl with curly blonde hair. Can you say sexual harassment? In another display of inappropriate humor, she announced from the bench in open court, "You know what, my P-Valley, my name going to be Passion. I got to go to that class, though, so I can learn how to climb that pole." People. Oh, why is this continuing? Juneteenth wasn't a national holiday until 2021. So that means this was June 8th. That one was June 18th, 2021. I believe it was 2021. Either way, it's 2020 or 21. It's 21. So we're 9 years into this, and she says she's been doing this for 9 years. Oh my God. Now, she frankly behaved as though the rules of the courtroom decorum did not apply to her. She did not hesitate to correct defendants for seemingly minor infractions. The video evidence I'm trying to get shows that she repeatedly admonished defendants for standing with their hands crossed or in their pockets instead of at their sides, and screamed at them when they indicated that they had not heard what she said. She also resented being called ma'am and berated defendants who attempted to show their respect for her by using that honorific, my bad. When male defendants referred to her as ma'am, she would chastise them, calling them little boy. Yes, ma'am. No, ma'am. Yes, sir. No, sir. It's a sign of respect. My attorney has told me for 20 years, call me Dave. I can't. It's Mr. I can't. It's yes, sir. Thank you, sir. It's a position that someone's helping you. You show them respect. Okay. My dad being an MP, CO, military, like growing up in the South for a good part of my childhood, there's a respect that you are automatically to give somebody. One in a position of us that could help you. Another one is just out of decency and politeness and courtesy. All right. I'm not going to be disrespectful. What you say? Okay, lady. Thanks, lady. Like, come on, man. On multiple occasions, she joked that she would be amenable to some sort of bribe in return for a lenient sentence. Huh? That's illegal. In open court, she engaged in dialogues with defendants about accepting kickbacks on fines and arranging hookups for herself and her staff for food and beverages, flooring, storage facilities. For example, EW appeared before Carr on July 22nd, 2020, to request that she grant him driving privileges in his 2018 case for driving under the influence of drugs or alcohol. After being informed that he worked for an automotive company, Carr told her staff, I got us another hookup. We could get our cars fixed here. And she said that she had already gotten them some flooring and carpet. EW told her to bring their cars in and the company would love to take care of them. Carr replied, always getting us the hookups. Don't worry. We don't have to pay. It's on him. Can you say Department of Justice investigation? I mean, like, the FBI's got to get involved in this kind of stuff. This is bribery of a sitting judge. And she openly admits it in freaking court. Like, I'm getting a headache just... I'm at a loss. The reinstatement of EW's driving privileges was subject to a mandatory $50 fee. But when he indicated that he did not have the money to pay the fee, Carr said, well, who's going to pay his 50? Puddin gets paid today, so does Mike. They both got 50. After all, you hooking us up. Mabel to pay your 50. $50 fee waived. All right, you're all set. Why is she not charged? On the journal entry, Carr wrote, no bitching necessary. She then passed the... Oh, my, what a piece of trash, man. She then passed the journal entry to a bailiff and told him, show that judgment entry to Ms. Puddin. As Gray read the entry, Carr broke out laughing while her bailiff called the next case. During her disciplinary hearing, her counsel questioned her about her undignified manner in the courtroom. Her own attorney questioned her about her undignified manner in the courtroom, including her loud, boisterous behavior, her use of sing-song tenor on at least one occasion, her use of a really loud voice when speaking to a defendant, as though the defendant would be more likely to understand her if she talked louder. You know, when someone doesn't speak another language, so you say it again and louder. Oh my God. But Carr offered no explanation for her behavior. Her own attorney questioned her, and she's like, because I freaking can. Oh, this next one. Yeah, we're going to count 5. We're going to get to on the next one because this, The parties stipulated and the board found that Carr's conduct with respect to this count did in fact violate Judicial Conduct Rule 1.2, 2.2, 2.8a, providing that a judge require order and decorum in proceedings before the court, and 2.8b. Yeah, we're not going to get into E right now because it's a video in itself. This is disgusting. Absolutely disgusting. So guys, what we have here is we have a sitting judge openly admitting to being willing to and having accepted bribes while on the bench. Look at this piece of trash that's willing to sell you out if it can get her something better. Now, we all like to hook up. We all like to, I know somebody. You don't think that you're going to go to court and be able to pay off the judge, and the judge openly admitted in open court, and everyone laughs about it like it is what it is, because you know what? That's the behavior and the pattern that they have shown and has been accepted and approved within this courthouse. They know They've been knowing for years what's been going on in that courtroom and didn't do a damn thing about it. Everybody in that courthouse is responsible for this woman's behavior and a disgusting and a just absolutely reprehensible actions that put people like you or me that are not willing to break the law. You know, we might get hemmed up on something stupid like a traffic citation or something. I'm not willing to bribe a judge to get off of a citation or something. Oh my God, this is. Oh, wait till you guys see the next one. I think we're going 2 more videos after this. Well, as always, when what the hell's happening in Cleveland Municipal Court? I'm Great Lakes. Thank you for being here. Take care of yourself and each other. I'll see you.